My name is Justin Holt. I am the owner and managing attorney of Mallory, Lawler, Holt and Associates, PC. It is one of the largest Class C misdemeanor defense firms in Texas.
My name is Judge Lauren Renee Sepulveda. I am the presiding municipal judge for McAllen Municipal Court in McAllen, Texas.
My name is Michelle Voren, and I am Senior Assistant City Attorney for the City of Plano, and I am Chief of the Prosecution Division. When you receive a traffic citation, you will need to make an appearance on that citation. You can go to the courthouse where the case is filed, so that will be the city where you received the citation. You can go to the clerk's window in person and make an appearance. You can either handle the case by paying the fine or seeing if there is another option to keep it off your record at the clerk's window, or you can ask the clerk to set the case for court so that you can discuss it with a prosecutor or a judge to find out your options.
The citation itself, the piece of paper that a motorist will leave the roadside with, involves several pieces of information. One of those pieces of information near the signature block is going to identify the location where an individual is required to appear. So the address and phone number and often websites are all listed on the document that the motorist leaves the roadside with.
Traditionally, the first step is that your clerks are going to be the first people that have contact with anybody that receives a traffic citation. That person is going to come in and enter a plea on the traffic citation. They have to do so within 10 days, or they could face additional charges for failure to appear or violation of promise to appear, which is an additional fee. At that point, then they'd enter a plea, and they can either plead guilty or no contest and take care of the ticket. They may qualify for a way to keep it off of their permanent driving record. Sometimes we offer deferred adjudications or driver safety course options, or they may just pay the straight fine. Now, if they want to contest their ticket, then we would give them a pretrial setting, and that's when they would actually come into the court and we'd start the trial process.
There are several different options for an operator in the state of Texas to resolve a citation involving motor vehicle control. It's option number one to resolve a speeding allegation would be to complete a statutory driving safety course. Under the Texas Code of Criminal Procedure, a driver once every 12 months, provided they qualify, may complete this driving safety course in order to dismiss a motor vehicle control violation. The qualifications are, first, you must have a valid Texas driver's license. You must also present proof of an insurance policy naming you as an insured driver. Your allegation may not have been for excessive speed, meaning 25 miles or higher over the posted speed limit, or 95 miles an hour or more, period, over the posted speed limit. You must also make your request to complete the driving safety course within a certain number of days, usually before the expiration of your appearance date, which will be listed on your citation. And upon approval, then the court will collect from you a court cost, which typically ranges from $100 to $134, plus an administrative fee of $10. And then you would be granted 90 days to complete the driving safety course, as well as return a certified driving history from the Department of Public Safety, which proves you have not completed the course in the prior 12-month period from the date of the citation. Deferred disposition is another option that is unique to the state of Texas that allows an operator to participate in what I like to refer to as a contract for dismissal. Like any contract, there are terms and conditions.
If you successfully complete deferred disposition, or you successfully complete the driving safety course that was approved by the judge, you typically do not have to go back to court. The judge will review the documentation at the end of that time period and automatically sign a dismissal without you coming back to court. If you violate the requirements from the judge, either you don't turn in proof of your driving safety course on time, or with a deferred disposition, you don't complete one of the other conditions that the judge has set, or if you get a new offense during that time period, then typically the judge will bring you back to court and has the option of finding you guilty of that offense because you violated the terms.
The defendant does not have the burden to prove their case, so that's solely on the state to bring the evidence, but they can present any evidence if they want. They can waive their Fifth Amendment right not to testify and testify if they want to do so. They can enter photos, video evidence, and sometimes they even bring other witnesses to help prove up their case.
If the jury finds you not guilty, that is called an acquittal. Congratulations, you're done. You can stand up and leave the room. If the jury finds you guilty, typically the jury will then be released from the room and the judge will prepare what is called a judgment form, which will inform you of your rights to appeal. You can appeal any case that you want to appeal. Understand, however, if you're just unhappy with the result of the trial court, that does not guarantee that your appeal will be successful. When you appeal a case, there are requirements you must meet, and they are time sensitive. You must file a motion indicating that you want to appeal your case. You must file an appeal bond, which is double the fine amount of whatever the fine assessed by either the judge or the jury, because you have the option to have the jury assess punishment. And if you choose to appeal the case, then you must also pay for and obtain a copy of the transcript of the trial. An appeal is not inexpensive. It's not completely cost prohibitive, but it is an involved process. So be prepared that if you choose to appeal your case, that there are steps that must be taken relatively quickly, almost immediately. On the other side, if you just decide that you are going to accept the judgment of either the jury or the judge, then you would be required to make a payment of the assessed penalty, which again is probably going to be a maximum of $334 in most cases. And typically the court will grant you up to 30 days to make that payment. It is not usually necessary that a person have the money on them right then and there to make any payment before they can leave the building.